Madam Clerk.
Calling State of Minnesota versus Gregory Ulrich.
Brian Lutz for the state.
Shane Simons also for the state.
Gregory Davis for Mr. Ulrich.
Virginia Murphy for Mr. Ulrich, who's present in custody.
Thank you. We're here for sentencing today. Mr. Lutz,
Thank you, Your Honor. Would you prefer us at the podium? Is that
your choice.
okay? I'll stay here, Your Honor. Your Honor, this defendant brought an element of evil to the Atlantic Clinic Crossroads campus on February 9th, 2021, when he carried out his premeditated deadly attack. The deadly attack committed by the defendant destroyed the life of Lindsay Overbay, taking a mother away from her two children, Gavin and Ava, and depriving Lindsay Overbay of the opportunity to be a mother to her young children and to raise her children. This defendant took away a daughter and he took away a sister. This twisted attack committed by the defendant shattered the lives of the victims that he shot at the clinic that day and shattered their families as well. This attack committed by the defendant had a huge impact on the medical providers who were at the clinic that day and the patients who had the misfortune of being at the clinic on February 9th, 2021. And they continue to be traumatized by the attack carried out by the defendant. This attack carried out by the defendant was such a cowardly attack. Only a coward would shoot Antonia Franzen-Pruden in the back, helpless and innocent, as she laid on the floor. Only a coward would shoot Tammy Schaffler in the abdomen as she lay innocent and helpless on the floor. Only a coward would shoot Sherry Curtis, causing 6 gunshot wounds, helpless and innocent in that hallway as she asked the defendant why. Only a coward would shoot Jennifer Gibson as she fled out that side exit door. It wasn't easy for these surviving victims to come into court and to tell the jurors what happened to them, what the defendant did to them. But they did so, and they confronted the defendant with courage. When you talk about what a coward this man is, you have nothing to look at but his behavior when they testified. When they came in and testified and confronted him, he laid his head on the table and wouldn't even look these innocent, defenseless women that he shot in the eye. Only a coward would shoot Lindsay Overbay as she tried to escape from this attack out the same door that Jennifer Gibson ran from. The defendant shot and killed Lindsay Overbay. He took away a daughter, he took away a sister, and most importantly, he took away a mother to 2 young children, Gavin and Ava. For that, the defendant will be punished by spending the rest of his life in prison without the possibility of release. There was some good, Your Honor, that came from this senseless tragedy. The community response has been amazing. The community support for the victims of the shooting that day and everyone who was at that clinic has been never-ending. The clinic workers and the patients, they've come together and provided unending support to one another. It's been meaningful to me to get to know the victims and their families and to work to achieve a result that brings some sense of justice to this deadly attack. Out of this tremendously evil act, it's still, and was from the beginning, apparent how much good that there is in this community. And the defendant couldn't steal that from the community or from the people that he shot that fateful day. None of the victims are going to provide victim impact statements here today. They don't want to give this defendant any attention or any satisfaction. This defendant doesn't deserve a second of their time, and they're not going to give him a second. They testified before him, and we saw his cowardly behavior when they testified. They know that Gregory Ulrich is going to spend the rest of his life in prison without the possibility of release. Your Honor, with respect to sentencing, on count 1, premeditated first-degree murder for the death of Lindsay Overbay, I am asking that the defendant be sentenced to life in prison without the possibility of release. With respect to count 2, first-degree premeditated attempted murder for Sherry Curtis, I'm asking that the defendant be sentenced to 216 months consecutive. These are permissive consecutive sentences, and with a 0 criminal history, That's top of the box for count 2. I'm asking for the same sentence, 216 months on count 3, attempted murder first degree for Antonia Franzen Pruden. I'm asking for the same sentence on count 4. That's attempted murder first degree premeditated with respect to Jennifer Gibson. And then finally count 5, I'm asking for 216 months. That's attempted first degree murder with respect to the shooting of Tammy Schaffler. Your Honor, with respect to count 6, that's the explosive device count. That is not a permissive consecutive sentence, so I would ask for 45 months concurrent. It's a severity level 6 offense, and Mr. Ulrich gets 2 points for 2 of the victim's crime, which brings him to 4 points under the guidelines, and that's a middle-of-the-box 45-month sentence concurrent. The sentencing worksheets, at least the order that I received them in, had explosive device sentence first, but I think that was last in time, as we know from the testimony, so that should be sentenced last with the guideline sentence as I've indicated. With respect to count 7, that was second degree unintentional murder regarding Lindsay Overbay. That's a sentence, Your Honor, under 60904, which is a lesser included offense, and I would ask that the guilty verdict remain, but that he not be convicted or adjudicated in connection with that count. And then with respect to counts 8 through 11, under 609.035, Your Honor, those are from the same behavioral incident. And again, I would ask that the verdict remain, guilty verdict remain, but that he not be adjudicated or convicted on any of those counts. Your Honor, by my count, he has 494 days of jail credit he's been in continuously since the offense date. With that, Your Honor, I have nothing else to say.
Mr. Lutz, can you clarify the sentence on the incendiary device? Because I think DOC had that worksheet incorrect, as you indicated, but what is the sentence that you're requesting on that charge again, please?
Your Honor, the sentence I'm requesting is 45 months, and I arrived at that recognizing it's a severity level 6 offense, and when sentences for multiple victims are pronounced at the same time, you can only use the points for 2 of the victims. So he gets 2 points for count 1 and 2 points for count 2, which puts him at 4 points, and then 4 points on a severity level 6 offense. The range is 39 to 54, with 45 being the middle of the box. And given that that is a concurrent sentence, I just went with 45 as my suggested duration for the court.
Thank you.
You're welcome.
For the defense.
Could I have just 1 second?
You may.
Your Honor, we have no plans to make any sort of statement. I do, however, need to raise an issue, and it's because it was brought up with regards to that sentencing. I am unsure as to the appropriateness of the enhanced 2 points for each of the first 2 other charges, victim charges, to get to the 45 days. It doesn't mean anything. He's going for life without parole, but I haven't had a chance to do any research on that. Or just to clarify, I just wanted to make sure that it was correct. We do have some concern that out of the same course of conduct that may be something that should remain at the lower level. Not that it changes anything with the top sentences, but we want to put it on the record that we would have a concern with that. And I haven't had time to research anything because we just found out about it today from Mr. Lutz's statement.
All right, so are you asking for some relief relative to that count?
Your Honor, I would simply ask that it be sentenced at as indicated with the 21 months and execute the 21 months with all its other files.
All right, thank you.
Yeah, I can give a cite from the guidelines. It's 2B.03, and it's paragraph lowercase e, parentheses 2, single course of conduct, multiple victims. It says when multiple current convictions arise out of a single course of conduct in which there were multiple victims, weights are given only to the 2 offenses at the highest severity levels. And because I'm asking for consecutive sentences on the other victims, it drops back to 0, so it wasn't applicable for the other counts I was asking.
One moment, please. Great, thank you. Mr. Ulrich, other than materials previously submitted, is there anything you wish to say?
Yes, I do. This will take less than 5 minutes. The victims and the public should know that there are reasons why the attack on the Illini Corporation could have been avoided. One pain pill in the emergency room 6 years ago would have allowed me to talk, but the pain was so horrific because I ran out of pain medication right during surgery. The nurse reported an overdose because I was out of my mind in pain, and she wrongly thought it was an overdose. The blood test proved there's no alcohol, no drug use for 30 hours. How can it be an overdose? Scientific blood test documents, which I have in my possession, and the victim's civil attorney should read the hospital lab and the nurse's false report. The ambulance and police also agree with me. Officer Jacobson was in this court testifying recently, and he was there 6 years ago. He happened to be the same police officer who agrees with me that there was nothing wrong with me. I called the ambulance crew by phone. They said it was the craziest run they ever made. To bring me without going to the hospital from Buffalo to downtown Minneapolis and call it an acute life-threatening opioid overdose, and I'm an EMT. I have perfect vitals on the couch in my house, perfect vitals hours later, perfect vitals the first day I was incarcerated at the hospital, second, third, fourth, fifth, sixth, seventh day, my vitals did not change for 7 days. I was tortured horribly, and they attributed the pain to withdrawals. I would really love the civil attorney to talk and look at these documents and see how ridiculous the Summit Orthopedics, Abbott Hospital, and Illini were, and what the doctors and nurses did, the blood test, the scientific, there's other witnesses and testimony. I'm not looking for leniency, but justice for the victims. Ulrich is the only one of many responsible. There are other people besides me responsible for me being out of my head. There's been no harm in a civil attorney from the victims or whatever to talk to me and observe the proof. During surgery, I had 100 stitches, and they went into my bone and spine through the front and through the back, and I didn't get one pill from Illini, one pill from Abbott, one pill from Summit Orthopedics. None of the doctors gave me one pill after surgery, after I left the hospital. And it's all because they said, well, he must be going through withdrawals. gee whiz, she must have taken a lot of drugs, but it was just pain, the blood test proved it. So I don't understand how all this came about, and I had to be in agony for 6 years looking for some relief, and that drove me out of my mind. And I'm not trying to escape responsibility, but I think there's justice enough to go around for me, Bergdorf, Anderson, and Hoffman, the three people, especially the nurse Hoffman, who said, he's on drugs, he's drinking alcohol. How do I have zero alcohol? And why didn't I go across the street to the emergency room in the Buffalo hospital? Why did they take me all through downtown, no lights and no siren? And there's not enough time to explain it. I would love to talk to a civil attorney on behalf of the victims and be sure that those hospitals paid for causing me to lose my mind. And as far as putting my head on the table, that's because I was in pain. I'm not ashamed of anything, and I'm not a coward. And 6 bullet wounds from one bullet makes it sound like I shot him 6 times. It was one bullet. Everybody got one bullet as far as I know, except one of the receptionists. And it was a twisted attack by the providers of the hospital and the medical community. They attacked me. And the evil that they perpetrated is in this documents. Thank you.
In considering the issue of sentencing here today, I'm keenly aware of the fact that there are no words to adequately acknowledge the horror and the tragedy that occurred at the Alina Buffalo Clinic on February 9th, 2021. A medical clinic is a place that people go to seek care and help. It's a place where staff report every single day. They report to work to help others. It is not a place where people expect to be shot. It was simply unthinkable prior to February 9th of 2021. The patients and the staff in the clinic that day came before the jury and before this court and testified about what happened, including their pain, their fear, their terror, their attempts to protect themselves, their attempts to protect each other, and the extremely significant impact these crimes have had on their lives. Jury also heard about the actions of law enforcement who took mere minutes to devise a plan and rush into the clinic, despite not having protective equipment, not knowing what they would face or whether they themselves would go home to their own families that night, but wanting to try and save the people in the clinic that day. While words are woefully inadequate, the court wishes to acknowledge the strength, the courage, and the resilience demonstrated and conveyed during the testimony of the many individuals who experienced both physical and psychological harm that day. Gregory Paul Ulrich, I hereby adjudicate you guilty of the crime of murder in the first degree with premeditation in violation of Minnesota Statute 609.185, subdivision A, sub 1, as to the death of Lindsay Marie Overbay by virtue of your conviction at trial. Standing convicted of that crime, it is the sentence of this court that you shall be committed to the custody of the Commissioner of Corrections of this state for the remainder of your lifetime. As to the next 4 sentences that I am imposing today, the court hereby orders consecutive sentences. Because the decision to impose consecutive sentences is permissive and not mandatory, the court finds that doing so does not exaggerate the criminality of the conduct of these offenses. The maximum sentence for each of these counts of attempted murder in the first degree is 20 years in prison. However, the law requires, as indicated by Mr. Lutz, that I need to utilize a criminal history score of 0 in calculating the length of the sentence for each of these consecutive sentences after the first sentence is imposed. With a criminal history score of 0, the range of the presumptive sentence for attempted murder in the first degree under the sentencing guidelines is 153 months to 216 months. In deciding the sentence to impose within this range, the court considered the fact that after shooting 5 people, the defendant set off explosive devices and left one explosive device undetonated. The defendant's actions impeded and delayed medical care for those injured that day, as well as interfered with the rescue of those within the clinic. Ordinarily, a minimum of 2/3 of each sentence would be served in prison, while a maximum of 1/3 of each sentence would be served on supervised release. However, in light of the sentence just imposed by the court, supervised release will not occur, and therefore the court will not pronounce the possibility of supervised release in imposing the remaining sentences. Similarly, the court would ordinarily give the defendant credit against his sentence for the time he's already spent in custody. Given the sentence of life imprisonment without possibility of release, the credit for the time already served does not reduce the sentence. For purposes of the record only, the court finds the defendant has been in custody for 494 days. As to count 2, I hereby adjudicate you guilty of the crime of attempted murder in the first degree, premeditation, in violation of Minnesota statute section 609.185, subdivision A1, and Minnesota statute 609.17, subdivision 1, as to Sherry K. Curtis, by virtue of your conviction at trial. Standing convicted of that crime, it is the sentence of this court that you shall be committed to the custody of the Commissioner of Corrections of this state for the period of 216 months. This sentence shall be consecutive to the other sentences pronounced here today. As to count 3, I hereby adjudicate you guilty of the crime of attempted murder in the first degree, premeditation, in violation of Minnesota statute 609.185, subdivision A, sub 1, and Minnesota statute 609.17, subdivision 1, as to Antonia Franzen Pruden, by virtue of your conviction at trial. Standing convicted of this crime, it is the sentence of this court that you shall be committed to the custody of the Commissioner of Corrections of this state for the period of 216 months. This sentence shall be consecutive to the other sentences pronounced here today. As to count 4, I hereby adjudicate you guilty of the crime of attempted murder in the first degree, premeditation, in violation of Minnesota statute 609.185, subdivision A1, and Minnesota statute 609.17, subdivision 1, as to Jennifer Gibson, by virtue of your conviction at trial. Standing convicted of this crime, it is the sentence of this court that you shall be committed to the custody of the Commissioner of Corrections of this state for the period of 216 months. This sentence shall be consecutive to the other sentences pronounced today. I hereby adjudicate you guilty of the crime of attempted murder in the first degree, premeditation, in violation of Minnesota statute 609.185, subdivision A, sub 1, and Minnesota statute 609.17, subdivision 1, as to Tamara Marie Schaffler, by virtue of your conviction at trial. Standing convicted of this crime, it is the sentence of the court that you shall be committed to the custody of the Commissioner of Corrections of this state for a period of 216 months. This sentence shall be consecutive to the other sentences pronounced here today. As to count 6 in this matter, I hereby adjudicate you guilty of the crime of use of an explosive device in violation of Minnesota Statute 609.668, subdivision 6C, which carries a maximum penalty of 20 years in prison, a $100,000 fine, or both. Standing convicted of this crime and based on your request for execution of this sentence, it is the sentence of this court that you shall be committed to the custody of the Commissioner of Corrections of this state for a period of 45 months. This sentence is concurrent to the other sentences pronounced here today. I am not imposing sentences on the other lesser included offenses for which you have been found guilty in accordance with Minnesota law. However, the court administrator shall record the guilty verdict returned by the jury on all the remaining unsentenced accounts. You are ordered to pay restitution for these offenses as determined in the next 90 days. Any restitution or the criminal surcharge imposed by the state shall be paid from prison wages or reduced to a civil judgment. Lawyers, are there any errors or omissions you wish to call the court's attention?
No, Your Honor.
No, Your Honor.
You have the right to appeal the judgment of conviction, the sentence, or both. If you are unable to pay the cost of the appeal, you may apply for leave to appeal at state expense by contacting the state public defender. At this time, we are adjourned. Thank you all.